See the money won't stay for your meal, getting all the piece of pie for your wife. Everybody wanna know how it feels. Everybody wanna see what it's like. Living in a big house, I don't mind. Me and Misty is so endless, the place to make your money. Alright.
Hi everyone, and welcome to another Crim 210 lecture. For this week, we're going to be talking about how the courts and how corrections respond to youth that are being adjudicated. So for the court process, we'll talk about decisions that are made by judges, Crown Counsel, and Defense Counsel, especially with respect to decisions about whether a youth will be remanded, that is, to be detained in custody or awaiting their trial, or released back into the community on different types of bail conditions. For the corrections aspect, we'll talk about how different persons in the justice system, but especially probation officers and treatment providers, create intervention strategies to try and prevent young persons from continuing their involvement in the justice system. So we're going to begin today's class by talking a little bit about the court system, which when I was an undergraduate student, this was what I was most interested in. As I've mentioned before, I did my field practice at Rankin & Bond Law Firm, and I worked under Phil Rankin, and I was lucky enough that Phil volunteered to do some duty counsel in the youth court system to provide me with some experience and exposure to how the youth court system worked. And we primarily focused on cases that were in regards to decisions about whether a youth would be released into the community or remanded. But for now, I'm going to talk a little bit about how the court can compel a young person's attendance in court. One way is through a summons or appearance notice that can be delivered by police. Basically, it's rarely actually used in Canada. It's more of a US-based phenomenon. Another one is called a promise to appear or an undertaking to appear. And this is where a police officer will deliver to a young person a notice, and this will work the same way for adults as well, where they are told that they have to appear in court on such and such a date, and that they have conditions that they must abide by while they're awaiting the court date. And these are what are sometimes referred to as statutory conditions. Statutory conditions are those conditions that basically apply to everybody that receives a promise to appear. So they're not unique conditions. They're the conditions that aren't specific to any one individual, just more broadly. And so some of these conditions, and we'll see them if youth are released on bail as well, include a no-go. And this is what's referring to where a youth is restricted from entering a particular geographic region, whether it be a specific school or a specific neighborhood, or like Metrotown Mall is another common area that youth in Burnaby are banned from. A no association, sometimes called a no contact order, prohibits the young person from having contact with certain people. These certain people might be the victim of the offense and their family, or they're co-accused. And so police have a vested interest in separating the young person from their co-offenders for several reasons. One is to prevent them from becoming involved in certain offenses. My dog does not appreciate that condition. The second is to ensure that these two individuals or multiple individuals don't get together to try and get their story straight, or where the one co-accused will actually threaten the other co-accused and say, like, if you testify in court, if you say anything, if you plead guilty, I'm going to get you, I'm going to hurt you, or I'm going to find someone to hurt you. And one thing that I'll address in upcoming lectures with respect to gang involvement especially, is that there's not a lot of loyalty among persons in conflict with the law. That's kind of one of the big myths, that gang members are loyal and that there's this type of like brotherhood and family, blood in, blood out type of perspective. And this is a real myth of gang involvement and offending more generally. We very often see persons in conflict with the law will rat out their fellow co-offenders. Individuals who offend are also highly likely to experience victimization as well. So part of separating the co-accused is to ensure that those two co-accused do not hurt one another. Another statutory condition is just called keep the peace and be of good behavior. And this can be interpreted very, very broadly, and there's been a lot of questioning about what constitutes keeping the peace. There have been court decisions, and this is more so with respect to immigration matters, but where individuals have been found to not be keeping the peace because they fail to appropriately take out their garbage on the right day of the week. Like maybe they were supposed to have their garbage out on the curb on Tuesday, but they put it out a day early, or they had their garbage picked up on Tuesday and they didn't bring their trash cans in until Thursday. So there's been really petty, pedantic ways in which individuals have been sort of breached for failing to keep the peace. But this is mostly related to like the intent, the spirit of the law was more around like not to go around yelling and screaming in the streets, causing problems in grocery stores, things like that. The abstention from no alcohol and drugs is another common statutory condition, very straightforward. Another statutory condition is that an individual is to possess no weapons, and I always get a kick out of this in court because they use very precise language where they'll say, you're not to possess any weapons or knives except for in the immediate preparation or consumption of food or for work purposes. So they say like, okay, yeah, you can have your knives when you're cutting your steak, but then you have to put it away and you're not allowed to possess them outside of the immediate preparation and consumption of food. Another one is curfew, and this is one that youth are especially likely to breach. And so I want students to think about these conditions and how many of them you think that you would have been able to follow. If you lived in Burnaby and you were banned from Metrotown Mall, and you were banned from seeing your two best friends, and you were required to be home by 8 p.m., and you were required to adhere to these conditions for months on end, how many times do you think that you would slip up, or do you think you would not slip up at all? I think it's just sometimes unreasonable to expect young persons who are often coming from very tumultuous, chaotic backgrounds to be able to follow these conditions to a T all the time. And in fact, I think it's kind of a good thing is that we'll see probation officers and other persons responsible for breaching individuals if they fail to abide by these conditions, but sometimes probation officers will kind of not turn a blind eye, but give warnings and say like, hey, you've been doing really good, you slipped up this one time, we're gonna let it go, but this is your warning. Like, you can't keep messing up like this, you have to follow your conditions. And if a young person doesn't follow those conditions, they can receive a breach, and that can result in a new criminal justice system charge. The other element that I'll talk about in detail is that pre-trial detention. Another word for that is remand. And so far, the Youth Criminal Justice Act has done a really poor job of reducing the number of youth on remand. In fact, remand has basically steadily increased over around the last 10 years, and youth are also spending more time on remand. So what does remand mean? It's where you're in custody, awaiting your trial, awaiting sentencing, awaiting all the other outcomes of the court process. One of the goals of the YCJ was to try and reduce the use of remand, and here's why. So number one, you're incarcerating some person who has not actually been found guilty of an offense. Everyone has the right to the presumption of innocence, and yet we see remand used over and over again. Our justice system says we're going to presume that you're innocent, but also we're going to put you in custody while we determine whether you're innocent or guilty. I actually think that there are very good reasons to use remand, but there are also some very wrong reasons to use remand. One of the issues with remand, and it's maybe a bit more of an issue for adults compared to youth, is that while on remand, an individual has not been found guilty of an offense. So if they've committed, say, a sexual offense, it is not possible to initiate treatment for sexual offending until that person has been found guilty of an offense. And so if a person is on remand for 4 months, 6 months, they might not be getting any treatment for the types of offending that they have been involved in. But the amount of time they spend on remand is credited to them after their sentence. And in fact, it used to be that the individual would basically automatically get 2-for-1 credit while on remand. So what does that mean? If an individual was remanded for 4 months and they received, at the end of their court process, a sentence of 8 months, well, because they had 4 months in custody already while awaiting that sentence determination, and they get 2-for-1 credit, that means they've actually already served all 8 months of their sentence. So they would actually be released right at sentencing. So that basically how it would work is like, okay, sir, madam, you have now been found guilty of this offense. I've read the pre-sentence report, heard the submissions from Crown Counsel and Defense Counsel, and I'm going to sentence you to 8 months in custody. I'm going to give you 2-for-1 credit, so you're out the door. You're now released. You're free to go back into the community. So the individual who's been in custody all this time hasn't really been receiving treatment for the offense-specific risk factors that have resulted in them being in custody in the first place. This is a much bigger problem in the adult custody centers, because in the adult custody centers in BC, for example, we have separate centers for those who have been remanded and separate centers for those who have been sentenced. So we'll have, for example, Surrey pretrial and North Fraser pretrial, solely for those individuals who have been remanded and are awaiting the outcome of their trial and their sentencing. Then we'll have other institutions like Mountain Institution, like Fraser Regional Correctional Center, that are reserved solely for those individuals that have received a custody sentence. So they're not on remand. So these pretrial detention centers, they're not designed to have a lot of treatment and intervention strategies implemented at that point. They're almost more like triage centers. People are moving in and out relatively quickly. And so it's very difficult to provide the appropriate intervention and treatment strategies in these centers. For youth, on the other hand, for example, the Burnaby Youth Custody Center includes individuals that are sentenced and individuals that are remanded. And sometimes sentenced individuals and remanded individuals are actually living in the same unit together. So we're more likely to see better conditions for youth on remand compared to adults on remand. But that's not to say that there are still some limitations of the use of remand. One of them being we don't really get to intervene on those offense-specific factors because we can't assume that the individual has been or is guilty of the offense that they're currently being adjudicated for. We know now what remand is. How are the decisions about remand made? How do we decide who is remanded and who is released on bail into the community? And most of the decisions about remand have very little to do with the offense that the person has committed and is before the court for. Most decisions about remand come down to the primary ground or the secondary ground. The primary ground is where the individual needs to be remanded to ensure attendance in court, to make sure that they actually show up to court. The secondary ground relates to the need to prevent the individual from committing future crimes against or having contact with the victim. So just like those no contact associations that I mentioned before, in this case, under the secondary ground, Crown Counsel might argue that this individual is at risk or likely to contact the victim of the offense to try and threaten them against testifying in court, or wants further payback against the victim because the victim contacted police. Other times it will be because it's almost impossible to ensure that the individual does not contact the victim, especially if the victim is a family member. So if the young person has committed a sexual assault against their younger sibling, what will we then do? How would we then respond to that young person if we're trying to prevent that individual from having contact with the victim? They live in the same house. It'd be very difficult for them to not intersect. Maybe the young person could go live somewhere else, but if that isn't really an option for that young person, it's more likely that they would be remanded under the secondary ground. And this family dynamic can actually result in serious problems. I might have mentioned it in the past, but while I was working at the law firm, we had an adult client who was charged with attempted murder. During a Thanksgiving dinner, he took a plastic bag and wrapped it around his mother's head and tried to tie the plastic bag around her head to force her to suffocate. This person suffered from a very serious mental illness. This person was actually allowed to have bail. They weren't remanded, they were released into the community under the condition that they are to have no contact with the victim, aka their mother. And so here's what I maybe should have mentioned from the outset. No contact doesn't mean, okay, you're not allowed to touch that person. It means you're not allowed to speak to that person. You're not allowed to email that person, text that person. You're not allowed to try to communicate with them through a third party. So you can't ask your sibling to say something to your mother if you have a no contact order with your mother. So in this case, because our client, not really my client, but the lawyer who I was working for, his client, because in part due to his mental disability and mental illness, when he came to court, right before the judge was about to walk in, he was sitting right on the bench next to his mother having a conversation. We had to grab him and pull him away and explain to him, no, you can't contact her. You can't have any communication with her whatsoever. And this sort of highlights another problem. I've kind of gone on a tangent here, but it highlights another problem with the conditions that courts implement against persons in conflict with the law. We know that persons in conflict with the law very often suffer from drug addiction, mental illness, mental disabilities, and sometimes they just have a very difficult time understanding what these conditions are. Like I'll hear in court when a person is released on bail, a judge will say things like, or a justice of the peace will say things like, okay, your no-go area is the 700 square block of Granville Street and Robson Street, or something like relatively complicated. Some individuals have a real difficult time, if they've long suffered from drug addiction or mental illness, understanding what it means to not be allowed to be in a square block. Like, how do we define that square block? So I think that we as a justice system could do better in communicating what these conditions mean to persons who are being released on bail. Okay, so primary ground, ensure attendance in court. Secondary ground, to ensure that the individual does not have contact with the victim. The tertiary ground is basically in cases where if the individual under investigation is released into the community, it would bring the criminal justice system into disrepute. So what we mean by this is that if an individual has committed a particularly horrific offense, like let's say we're talking about Clifford Olson, Robert Pickton, we looked at, for example, for younger persons, individuals like Tristan Vickers in the Lower Mainland, or Cruz Wellwood and Cameron Moffat from Victoria, who committed sexual homicide offenses. Their offenses were so horrific that even if we could ensure that they would always attend court, and even if we could ensure that they were not going to have any contact with their victims or victims' families, if they were released, the public might begin to lose faith in the ability of the justice system to protect its citizens. And so in such circumstances, the Crown Counsel or the judge will argue and agree that we need to hold this person in custody, basically so people don't lose faith in the justice system. Now, you could definitely question whether this is a fair ground or not, because the offense that maybe is believed to be so horrific as to justify incarceration is also an offense that the individual is supposed to be presumed to be innocent of. We're not going to assume guilt, we're going to assume innocence, yet we're going to detain that person because of the severity of the offense. So it's an interesting question to ask yourselves. I still think that there are certain instances in which the tertiary ground is absolutely justified, but I don't really see it as justified in terms of like what the public might think. I just think that it's justified in terms of the level of dangerousness that an individual poses to the general public. And that if that person were to be roaming the streets, free, even if they were innocent of the offense that they're before the court for, they still pose a danger to the public because the underlying risk factors mean that they can still be at risk of committing other serious offenses. So now we'll take a closer look at each of the primary, secondary, and tertiary grounds. When it comes to youth, maybe the most common reasons for why a judge will deny bail under the primary ground relates to if the youth has no fixed address or if the youth cannot be returned to a suitable caregiver. So NFA, or no fixed address, essentially means that the young person does not have a stable residence or a home to live at. The suitable guardian question is kind of straightforward. If the judge believes that the parent isn't going to be capable of ensuring that the youth attends court, then the youth is more likely to be detained under the primary ground. And I can kind of take issue with both of these justifications because we're almost criminalizing not the person's behavior, but the person's socioeconomic status. A more justifiable one is if the youth has a prior history of not abiding by court conditions and not showing up in court. So if we're talking to little Johnny, and Johnny is now 15 and has got like 16 breaches in their past, well, okay, maybe they cannot be counted on to appear in court, so maybe their remand is necessary. For that secondary ground, reasons to deny bail relate to whether it's impossible to keep the young person separate from the victim, such as if they're living in the same home. We can also take a look at the person's conduct post-arrest. For example, maybe they, while awaiting their bail hearing, maybe they had already reached out to threaten the victim. Like, young kids are particularly, I don't want to call them stupid, but young people in general just make poorer decisions than adults, and we know that this is a lot to do with the development of the brain, impulsivity, poor functioning in the frontal lobe, or underdeveloped frontal lobe and temporal lobe. And so they'll get on Instagram or whatever, and they will message the victim and say like, hey, if you talk to the police, I'm going to kill you. And then the victim screenshots this, shows this to a teacher, shows it to the police, and now the young person can easily be detained under the secondary ground. Same thing pre-arrest. So maybe the individual thinks that they're about to get caught by police or doesn't want the victim to come forward, so they threaten the victim, and that's a good indication that, well, they threatened the victim went to police anyways, maybe the young person is going to try to get retribution. There's a very important section of the YCJA, it's section 29.2, basically creates a rebuttal presumption that detention on the secondary ground can only be justified if the person could also receive a custody sentence for their index offense. The index offense is the offense that they're currently before the court for. So remember a couple of weeks ago we talked about 4 gateways to custody under the YCJA, and I'll go over them again today. If the young person isn't before the court for one of those sort of 4 offense types, then the secondary ground cannot be used even if there is evidence of coercion pre-arrest, as an example, or coercion post-arrest, or there's a threat that the individual is going to contact the victim because they live in the same home. So the secondary ground can only be used to justify remand if the young person has committed an offense for which, if they received a sentence for that offense, that sentence could be a custody sentence. That tertiary ground I kind of talked about in a bit of detail, but basically if there's no way to justify the primary ground or secondary ground, but it's a particularly serious offense and the public would lose faith in the justice system, then Crown Counsel could try and apply for remand under the tertiary ground. For Crown Counsel, so if you're interested in being Crown Counsel, you need to understand that the tertiary ground is kind of like same logic as the use of a Mr. Big Sting. You can only really begin to think about the tertiary ground if you know that you would not be successful under the primary ground or under the secondary ground. We saw in the Luka Gordic homicide case that we've talked about before that many and the public were very frustrated that the tertiary ground was not invoked. This was a particularly serious offense, and Golich, one of the accused, was nevertheless released on bail. And so this was an example of where the justice system did come under scrutiny from the public. So maybe the tertiary ground should have been used here. When Golich was in court for his bail hearing, the tertiary ground was unsuccessful. and he was released on bail instead of being remanded. And that actually resulted in a lot of outcry in the public. So this might have been a good instance of where the tertiary ground could have been justified. Whether you agree with the tertiary ground in principle or not is up to you, but by the letter of the law, you could see why the tertiary ground could have been appropriate in this case. So I'm not sure if the Crown Counsel just did not apply under the tertiary ground, or whether the judge rejected the argument from Crown Counsel that the tertiary ground should be used or imposed to justify remand. I'm actually surprised that Golich wasn't detained under the secondary ground, because he had actually threatened one of the persons, a young woman, who was supposed to be testifying at Golich's sentencing hearing. But because he threatened this young woman, that really kind of allowed or justified Golich to be brought back to court and subsequently detained and remanded for that threat. So in this case, what I'm trying to say is that Golich was released, threatened a person, and then had his bail revoked. So he was placed on remand after uttering threats. My perspective is that if you looked at the circumstances of the case, it played out over social media. It was very well known in the media. There were a lot of individuals involved in the offense because there was a party up in Worcester, so a lot of people were aware. This really created a high probability that in some ways there was going to be contact between the individuals accused of the crime and those that were victims or a party to that crime. And so really there might have been justification right away for detention under the secondary ground. And what happened instead, Golich was released, the inevitable happened, he threatened one of the persons who was going to testify, and then was subsequently remanded. Okay, so what is the role of Crown Counsel in BC? As I mentioned, police officers are not responsible for formally charging young persons or any person who's before the court. There's a particular designated Crown Counsel in BC that's responsible for charge screening. So they'll look through the circumstances of the offense. They'll look through what we call a will say. It's a police officer's formal notes about what they will say during court to give an indication to the Crown Counsel about the degree of evidence that the police officer has that this young person is guilty of the offense. Alternatively, maybe Crown Counsel believes that the young person is guilty, but that processing that person through the formal justice system is maybe not worthwhile because the offense is not particularly serious, or because it's a young person's first crime. And so in this case, the Crown Counsel might elect to proceed through an extrajudicial sanction where the decision is handled outside the formal court process. It requires that the young person admit their guilt. And if they do admit their guilt, then they will go through the process of determining a sort of a penalty, which can include restitution or community service. And for example, a young person will be told that they have 6 months to complete 50 hours of community work service. And if they don't complete those hours of community service in the allotted time, then they can be charged for failing to comply with the conditions of their extrajudicial sanction. So they can actually receive a formal charge and a formal conviction. If they successfully complete their extrajudicial sanction, they will have no formal conviction on their criminal record. Judges also play an important role, but basically after Crown Counsel has elected to proceed with formal charges rather than an extrajudicial sanction. So for youth court judges, their main responsibility is the weighting of information. So they will get various sources of information from probation officers and mental health practitioners. And this can include a pre-sentence report that's completed by the probation officer, and sometimes will include in that report details of a person's forensic evaluation. In that pre-sentence report, if the individual is Indigenous, it will also include a Gladu report. Judges will also be there for like pre-trial conferences, weighting of victim impact statements, and making decisions on whether to sentence that young person as an adult. So if the young person has committed a particularly serious offense, then Crown Counsel may ask the judge to have the young person sentenced as an adult so that they would receive a lengthier sentence. And the Crown Counsel must demonstrate to the judge on the balance of probabilities that an adult sentence is necessary for protection of the public, one of the main goals of the YCJA. Okay, this one is very important. Presumptive offenses have been under a lot of scrutiny, maybe not as recently as 2021, but in the past 5 to 10 years, they've been very important. When the YCJA was first created back in 2003, written into the YCJA was this idea of presumptive offenses. So it was this presumption that if a youth was 14 or older and was found guilty of a serious and violent offense, and those offenses included homicide, aggravated sexual assault. So if a young person, 14 or older, was found guilty of one of those 4 offenses, there was what's called a reverse onus clause. This means that the burden of proof was placed on defense counsel to demonstrate why their young client would be better served and why the safety of the public would be better served by having that individual sentenced as a youth rather than as an adult. Basically, the onus was on defense counsel to show on the balance of probabilities why their client should not be sentenced as an adult. Another thing that maybe I haven't clarified yet, if a young person is sentenced as an adult, they don't actually get placed in adult custody. They serve their sentence in youth custody, and they can serve that sentence up until age 20. So here's how this works. Let's say an individual at 17 is sentenced as an adult to 3 years in custody. Once they turn age 18, they will be transferred to adult custody unless they can show why it would be more beneficial for them and why it would be more beneficial to their rehabilitation and the protection of the public by having that person remain in youth custody. Reasons often relate to the need to complete high school, or they've made connections to treatment providers in youth custody. In most cases, this application will be successful. So what I mean by that is the young person has turned age 18, but they will be successful in being allowed to remain in youth custody rather than be transferred to adult custody. The denial of such applications usually comes from instances where the now 18-year-old has a history of assaulting other more vulnerable kids in the custody center. So you've got 15, 16-year-olds who are smaller, less mature, and this 18-year-old is assaulting them or bullying them in some ways. That would be grounds for denying their request to remain in youth custody. So if their request is successful, they can remain in youth custody up until age 20. They still have to be on their best behavior. So it doesn't mean that they automatically get to stay up until age 20. The decision can be revoked like at any time if the individual is misbehaving. But once they hit age 20, there's no application to be made. They have to be transferred to adult custody. So for these adult sentences, these presumptive offenses that resulted in adult sentences, were eventually ruled by the Supreme Court of Canada to be unconstitutional because of the reverse onus requirement. There have been some major court cases under the YCJA that have influenced changes in the YCJA legislation. One of these cases is R versus DB, and so when we're dealing with youth court cases, we virtually always only see their initials. Where we might see their full name is where they have been sentenced as an adult and the court deemed that the young person's name could be released as part of that adult sentence. So sometimes a youth can be sentenced as an adult, but defense counsel can make an argument, and it's on the balance of probabilities, it's defense counsel's responsibility of showing this to be the case, that the release of that young person's name would threaten the public or would fail to be helpful in rehabilitating this person and then helping to protect the long-term safety of the public. So in R versus DB, this was where a fight ensued in a mall in Ontario, and DB knocked the victim to the ground, punched that victim, and the victim died of their injuries. This is where, as I just alluded to, presumptive offenses were struck down, where youth should be entitled to a presumption of diminished moral culpability, meaning that even if they have been found guilty of this serious offense, it should be assumed that they have greater prospects or greater chances of changing compared to adults, and therefore we should not have this reverse onus clause. So it's not like it got rid of adult sentencing, it just said that the burden of proof is now on Crown Counsel to show that the young person should be sentenced as an adult, regardless of the crime that the young person has been found guilty of. One of my very favorite justices is Justice Abella, because she's very attuned to the value of social science, and obviously I'm kind of biased since I'm a social science researcher, but it's always nice to see judges taking a look at what research says. And so she took a look at what research says about the moral development of young persons, and in that R versus DB case, basically said that if the young person is deemed to be less morally blameworthy, then we can't just automatically assume or presume, presumptive offense, that they have the same level of sophistication and understanding of why their behavior is wrong compared to an adult. So I'll just read off the direct quote here. She said that adolescents also lack the intellectual capacity to appreciate fully the consequences of their acts. There is evidence suggesting that as a result of this reduced judgment and maturity, young persons respond differently to punishment than adults. That is, that young persons can actually experience negative ramifications of punishment, that like labeling status, for example. And that harsher penalties do not by themselves reduce youth crime. So this was also a very big shot against specific deterrence. Basically, Abella is saying that even if we use a harsher penalty, it's not really going to factor into a young person's future decision to commit an offense or not. So these harsher penalties are kind of just pointless. And actually, no, not just pointless. We could actually be doing more harm. So it's not just that they have a null effect, that they could have a harmful effect on the rehabilitation of the young person. And crime control advocates could say, well, that's horrible. Why are we not punishing this person for the wrong that they have done? We need to protect society. And I think the counter argument is that, well, we are protecting society. We're figuring out what type of punishment is going to promote the long-term protection of society. And if rehabilitation is the best route to protecting society, that's what we should do. R versus Gladu is neither a case under the YCJ nor a case of a young person. In fact, so it's from 1999 and it was about a 19-year-old woman. But the decisions made in this case had implications for the procedures used under the YCJ. Often when we're looking at these particularly notable cases, they're notable in part because they involve especially serious offenses. And what you need to do as young scholars trying to study the law is separate the offense from the decisions made during the court process. Because sometimes we can see more non-punitive decisions being made in really horrific offenses or really horrific cases. And keep in mind that these decisions are being made to set precedent for not future cases that are exactly like serious homicide offenses, but where we're going to have other persons in conflict with the law who might be in similar social circumstances. In this case of R versus Gladu, it's another one that I've talked about before, where the young woman stabbed her husband to death, and she was heard by a witness as saying, "I got you, you fucking bastard," and was described as like jumping up and down, like as if she was playing tag, and then tag somebody was really excited to have gotten somebody back. This person received a 3-year sentence and was released on parole after 6 months. And so people can, and I understand why, can be kind of upset or angry at maybe viewing this as not a particularly proportionate punishment. The key aspect of this case is not the sentence length. The key aspect of this case is about how judges are to interpret Section 17(2)(e) of the Canadian Criminal Code. At trial, the trial judge said that only Indigenous persons living on reserves should be considered when applying Section 718(2)(e). And if you'll recall, 718(2)(e) basically says that a judge must consider all alternatives to custody, especially in the case of Indigenous persons. So they should be looking for alternatives to custody, especially for Indigenous persons, given their historical overrepresentation due to marginalization, attempted genocide, and so on. So the Supreme Court of Canada ruled that no, this aspect of the criminal code applies to all Indigenous persons. It's not like only those persons living on a reserve have been negatively impacted by colonialism. All Indigenous persons have been impacted, and especially if we look at Indigenous persons who are living on the downtown east side, they might be especially impacted by the past injustices that we'll talk about in a couple of weeks. So the take-home message in R versus Gladu is that under the YCJ, these Gladu reports need to be completed for all Indigenous persons, not just those who are living on reserves. R versus BWP was a case from 2006 where BWP killed a man during a fight, basically put like a billiards ball into a sock and then swung it around and hit the victim a couple of times. And again, one of those very serious offenses where we need to separate the act from the decision and the rule of law. And in this case, the court ruled that general deterrence could not be used as a sentencing principle under the YCJA. So one youth's crime should not result in them basically taking responsibility for all youth involved in crime. We should not penalize this person more strongly solely to try and deter other persons from wanting to commit a crime. And basically the Supreme Court of Canada looked at the YCJ and said, like, there are no aspects of the word deter or deterrence under the declaration principles of the YCJ. Deterrence is not listed as a purpose or principle under Section 38. It's not even included in the list of particular sanctions to be used under Section 42. So declaration principle, Section 3. Purpose and principles, Section 38. Particular sanctions under the YCJ, Section 42. The omission of general deterrence under these sections should be seen as purposeful. It was excluded purposefully because it was thought that general deterrence was not going to be helpful. You'll recall the 4 gateways that on their own were necessary but not necessarily sufficient for the justification of the implementation of a custody sentence. One of those 4 gateways is a violent offense. And R versus CD helped define what constituted a violent offense. So CD was in possession of a weapon, and the court ruled that violent offenses were defined by physical harm. So it created a much narrower definition of the scope of a violent offense. Weapons carrying could not be considered a violent offense. Uttering threats or acting recklessly, these could not be used to justify a custody sentence under the YCJA. CDK was basically heard at the same time as R versus CD, no relation between the two. Here, it was a case of dangerous driving, and again, it was because the dangerous driving did not actually directly involve bodily harm, nor the intent to cause harm. Therefore, a custody sentence could not be used. Alright, so we've hit the midway point of the lecture, so we're going to flip from courts to corrections. So corrections is what happens once a young person has been sentenced. So corrections doesn't just refer to custody centers. It refers to the larger umbrella of how we respond to persons that have been sentenced or even persons that are on bail. Under the YCJ, there are different custody dispositions and different non-custody dispositions. So basically, what can a judge elect to apply to a young person that will place them under the purview of correction? So these can include reprimands, which is basically just a simple warning, a discharge, which is to say the individual is guilty but will not have a criminal record. You can have absolute discharges, which is just to release them with no conditions, or a conditional discharge, which is to say that if you abide by such and such conditions over such and such a period of time, the offense that you've been found guilty of will be quashed from your record. Other non-custody dispositions can include compensation or restitution. So compensation is more like financial. Restitution is more giving back in some way, whether it's through volunteer hours, an apology, something like that. Other non-custody dispositions that we're more commonly familiar with include community service, a probation order, an attendance order, which is like you have to attend this treatment program. It's 3 months, it's a residential treatment program, so you'll be living here. And if you go AWOL from this treatment program, it will be considered a violation of your release or your sentence disposition. And so you'll actually receive new charges. It will be an example of one of those failures to comply with court orders, what we can call an administrative offense. Intensive Support and Supervision Program, sometimes just referred to as ISP. An ISP order is kind of like probation on steroids, where the individual is assigned a particular ISP worker who's there not just to be like the probation officer that administers the conditions and reminds youth of their appointments, make sure that they're abiding by conditions. The ISP worker is also like a mentor who can help the young person, go to different businesses to hand out resumes, or help them open a bank account or get a library card, things that maybe the young person just needs as part of their pathway to rehabilitation. This is definitely going to be a question on the final exam, so you'll need to know the 4 conditions under the YCGA which allow for the use of custody. These 4 conditions include a violent offense, if the individual has a history of administrative offenses, if the individual has committed an indictable offense and has a history of prior findings of guilt, so they've committed an offense for which an adult could receive 2 or more years in custody, and they have incurred prior convictions. 4th, they have committed an indictable offense and there are particularly aggravating circumstances surrounding this offense. So it was against a vulnerable victim like a child or an elderly person. That could be used as a condition that could allow for the use of custody. And you need to understand this part. These conditions are necessary but not sufficient. So just because a youth has committed a violent offense doesn't mean that they have to receive a custody sentence. It only means that a judge may now consider the possibility of a custody sentence. So there are 3 types of custody sentences under the YCGA. The first is what's called a deferred custody and supervision order. This is where the young person serves their custody sentence in the community. And I always smile or shake my head when having to talk about this to students because I get that it doesn't make a lot of sense. It's a custody sentence, but they don't actually serve any time in custody. So what the deferred custody and supervision order means is that the young person will receive a custody sentence, but they will serve it in the community and need to follow certain conditions. And if they violate any of those conditions, they're automatically placed in custody for the remainder of their sentence, and they will incur new charges for an administrative offense for failing to abide by the conditions of their deferred custody and supervision order. The second type of custody sentence is that custody and community supervision order. And this is where they right away are placed in custody. So that's where they start their sentence. Whether we're talking about the custody and community supervision order or deferred custody and supervision order, we know that under the YCGA, a youth only serves 2/3 of their custody sentence in custody. So if the young person receives a 9-month custody and community sentence order, they will spend 2/3 of those 9 months, so 6 months, in a custody center, and then 1/3 of their custody sentence will be served in the community where they're trying to promote their rehabilitation, allow them to return to school, have time to look for a job, find stable housing, anything like that. So while they're serving their 1/3 of that remaining sentence, so that remaining 3 months of their custody sentence, at any time that they violate the conditions of their release, they would be returned right away to custody. And very often there will be a probation order attached to a DCSO or a custody and community supervision order. For example, a young person might get that 9 months in custody followed by 1 year of probation. So they'll spend 6 months actually incarcerated, 3 months in the community serving the remainder of their custody sentence, and then once those 3 months are up, they will begin their probation sentence. And that probation sentence will also include specific conditions that they need to abide by. If they violate those conditions, they could return to custody. So they're not automatically returned to custody if they violate conditions of their probation order. They are returned to custody automatically if they violate the conditions of their community release while serving their custody sentence. For probation, if the young person violates those conditions, the violation results in a new criminal charge, and that goes before the court, and then the judge and the Crown Counsel will sort of decide whether they'll seek a custody sentence for that violation of probation. So if they violate probation, the case has to go to court. If they violate conditions of their community release, there's no court process. There's no, let's find out whether they're guilty of their no contact or violating their no contact order, or whether they're guilty of failing to abstain from drugs and alcohol. It is at the probation officer's discretion a choice to automatically return them to the custody center. The third type of custody sentence under the YCJ is what's called an Irks Order, Intensive Rehabilitative Custody and Supervision. And this isn't really actually elected by a judge, it's actually elected or recommended by the Provincial Director of Youth Custody. So this Irks Order is reserved for youth who have committed a violent offense and suffer from a mental illness or some form of emotional disturbance. So it's not necessarily the case that they have been formally diagnosed with a mental disorder, but that there is some indication that a mental disorder may be present. It's very expensive and rarely used. So here's how it works, because when I've been working in the custody center doing research, I would sit around at a huge conference table and listen to people get together to work on this Irks Order. So this Irks Order includes an entire team of a probation officer in the custody center, probation officer in the community, a mental health practitioner. So usually there'll be both like a clinician and a psychiatric nurse. And then it will also include, for example, the young person's case manager in the custody center as well. So it's this entire team that gets together to create an individualized treatment plan for while the young person is in custody, as well as while the young person is going to be in the community. So it's trying to have or avoid what we often see as an issue in the justice system, which is silo effects. So a silo effect is where a social worker has a piece of information on their client, and they don't share that piece of information with the probation officer who happens to have that same client, and vice versa. So we have a social worker, a psychiatric nurse, a probation officer, a police officer. They all know this young person before the court, but they don't necessarily share information. And so maybe judges don't get a full picture, or the treatment provider, the probation officer, trying to figure out what the best conditions are for the young person, but doesn't know information from the social worker, and the social worker knows that this young person is being abused in the home. So we need better communication across these different areas of work to develop the best, most robust treatment program. So Irks is kind of meant to try and tackle this. So to give some more details about Irks, the court can make this order only in specific circumstances, like if the young person is found guilty of murder, attempted murder, manslaughter, aggravated sexual assault, or has committed at least 2 serious violent offenses in the past in addition to a current violent offense. The young person also, as I mentioned, has to be suffering from a mental disorder, psychological disorder, those emotional disturbances, and there are reasonable grounds to believe that the treatment plan might reduce the risk that the young person will repeat that offense or commit further serious offenses in the community. So instead of having that automatic 1/3 release into the community, usually the individual will spend the full period of their custody sentence in the custody center so that they can get the right treatment plan and complete their plan of treatment. This only works if appropriate programs are available. So if the province has failed to actually develop, say for example, if the young person suffers from FASD, the province doesn't have an assessment center for diagnosing and responding to FASD, then it's unlikely for Irks to be used. A couple of years ago, I loved telling the story about a young kid that I interviewed while in custody. He came into custody when he was about 14 years old because he had perpetrated second-degree murder. Him and his 12-year-old brother came in around the same time, his younger brother for a different offense. But the second-degree murder offense that he had perpetrated appeared to be him committing offense against a gang member because he was worried that this gang member was abusing his younger brother. So this young person appeared to have FASD and appeared to have a bunch of other mental health disorders, including ADHD, conduct disorder. He was particularly low functioning, but he was a nice, quiet kid to talk to. I interviewed him a lot over about a 2-year period. I probably spent 20 to 30 hours in a room with this young person. So he was subjected to this Irks Order, so he spent about 3 years in custody, where he got a lot of treatment. He was released to the community, and he actually got a job, he began working not a trade school, but a culinary school, and then he got a job at a pretty good restaurant actually, as kind of like a sous chef or an assistant cook. And for a very long period of time, for about 5 years, he had completely abstained from criminal behavior. So I love to use this as an example of how Irks Orders really worked. But eventually the Irks Order ended, and after about a 5-year span, he reoffended by committing another homicide offense, and this time it was first-degree murder, where he actually shot another gang member. We could see this as maybe evidence that the Irks Order failed. An alternative perspective would be that Irks is actually very useful, and maybe it just needs to extend for a longer period of time. So we talked about how Irks Orders involve or need to have a particular treatment or programming element. So let's talk a little bit about what effective interventions with youth in conflict with the law actually look like. And one of the things that we know is that we need special treatment for youth in conflict with the law, because compared to adults, youth tend to have a less mature judgment, their brains are still developing, they are more likely to make poor decisions about offending opportunities, they're less likely to recognize the consequences of their behavior, they have poor psychological functioning, reasoning skills, they also can be a little bit more malleable. So while they're less culpable and blameworthy, they're more likely to improve in their levels of culpability. They're more likely to improve their emotional regulation and self-regulation. Their past is not prologue. What we mean by that is that what they've done in the past is not necessarily going to continue in the future, because we expect a lot of change in a lot of different ways in terms of morals, in terms of identity. We also know that young persons are not as good at communicating with their lawyers to make legal decisions, so they don't necessarily get the best possible defense. So there are different types of programs or interventions or responses to young persons. And Mark Lipsey is maybe most famous for his work on evaluating or summarizing what we know about the effectiveness of these intervention programs. He did what's called a meta-analysis. In short, a meta-analysis is where there is a statistical summary of past empirical research. So instead of doing a unique study, and instead of just doing a literature review, it's a statistical analysis of the average effect of a particular treatment program across a wide range of studies. So I'm going to show you details on the effectiveness of different programs. In parentheses, you'll see the average reductions in recidivism. Basically, a minus shows that the program is effective and a plus sign shows that the program made things worse. For example, we can look at surveillance. And this would look at, for individuals, young persons that received surveillance, was their likelihood of recidivism lower compared to individuals that did not receive surveillance? So we would randomly assign one youth to surveillance and one youth to non-surveillance, and then we would do this for a large group and then compare the prevalence of recidivism. So surveillance indicates that individuals who experience like surveillance by police officers, by probation officers, remember like that Yankee 10, Yankee 20 cars that I talked about for the policing lecture, about 6% lower rate of recidivism for those that were surveilled compared to those that were not surveilled. Specific deterrence actually increased recidivism. So giving a young person a more punitive penalty compared to another young person actually increased the likelihood of recidivism. The same thing for actual like discipline. So this can refer to things like boot camps, where a young person is sent to like those army-based programs that aren't very effective whatsoever. Restorative justice saw a 10% reduction in recidivism. Counseling, so helping the youth with cognitive behavioral therapy programming. So cognitive behavioral therapy is about trying to rewrite scripts. Basically, you react one way when you are angry or upset. You have this sort of pattern or this script. Let's try and get you to respond differently. So let's think about the problems that often make you particularly upset, and how can we change like the neural pathways in your brain so that you respond differently. Skill building, so teaching a young person like employable skills, or not just employable skills, but skills for dealing with problems that can also be very much aligned with cognitive behavioral therapy, are also particularly effective in reducing recidivism. So we'll now go through each of these 6 in a little bit more detail. So with surveillance, it's the idea that youth need monitoring so that we can make sure that they are abiding by their conditions. So probation and especially Irks orders would be an example of surveillance. And overall, they're kind of effective, but not as effective as other options. Where surveillance would be more effective is with an Irks order, where it's not just about surveillance, but about mentorship and programming, like counseling, as opposed to just, we're gonna watch you, but we're not gonna help you. The surveillance element is just like, Big Brother. It's not actually focusing on improving the underlying issues affecting the young person. It's more like saying, hey, if you mess up, we're gonna catch you. So that's why it could be a little bit effective, but it's not very effective. As I mentioned, deterrence is actually harmful. Another example of deterrence programs are scared straight programs. So if we randomly assign 50 individuals to a scared straight program, and for a random 50 individuals we do nothing, the group that received nothing is less likely to recidivate compared to the individuals exposed to the scared straight program. So having former persons who have experienced incarceration or currently incarcerated adults yelling and screaming at young persons about how awful prison is actually harmful. It will actually increase the likelihood that these young persons will recidivate. Discipline, I wouldn't really call them like boot camps. I would think more about discipline as like wilderness training programs that are trying to have the young person follow a really stringent schedule and get used to routine. The problem with these like wilderness training camps or wilderness awareness camps is that they provide the young person with very strict structure, but in very controlled conditions. It's very easy to follow a routine when you don't really have an option to deviate from that routine. Like if you're being forced to wake up at 6 a.m. every day and have breakfast at 7 and shower at 7:30. Like if you're being forced to follow that routine, you kind of don't have a choice to deviate from that routine. What happens is when the young person is taken out of that training program and placed back in their family home that's very chaotic, and they have to work on getting themselves to school, and there's like they don't get the sleep that they need because parents are up late at night drinking or using drugs, or there are different people coming in and out of the house. It's harder to have the agency to maintain that routine that you've been taught. Where these wilderness training programs can be effective is if the young person, when returned to the family home, gets treatment, gets counseling in addition, so that they are better able to put the skills that they learned into practice in this more chaotic environment. Restorative programs include both restitution and mediation. Restitution is more about giving back. Mediation is more about resolving the conflict, and mediation is a little bit more effective than restitution-based restorative programs. Overall, restorative programs are quite successful. I'd argue that we have to be careful about who we use restorative programs for. For an individual with strong features of psychopathy, they might use this restorative program to try and inflict further harm on an individual. Restorative programs don't need to be restricted to persons that have committed only non-serious offenses. A great example of this is the Rena-Virk case. This happened maybe 20 years ago in Victoria, where Rena-Virk was swarmed by a group of teenagers and brutally beaten and murdered. Two of the leaders of the homicide against Rena-Virk were Kelly Ellard and Warren Glowatsky. Kelly Ellard basically never took responsibility for the offense, basically never showed remorse, and so she was not a good candidate for restorative justice. On the other hand, Glowatsky showed true remorse and regret for his involvement in the crime and participated in a restorative justice conference with Rena-Virk's parents. And there was healing done. He was able to apologize. The mediation that occurred between him and Rena's parents actually resulted in Rena-Virk's parents and Glowatsky going around to different schools and talking about the value of restorative justice and how it helped the victims heal and how it helped Glowatsky sort of reconnect to the community and feel like their label is not as an offender, it's not their sole status, and that helped them from avoiding further involvement in the justice system. Counseling is a pretty broad term. There are a lot of different types of counseling. We can have one-to-one counseling that's referred to individual counseling, or also group-based counseling. For adults, we tend to maybe see individual counseling being particularly effective, not so much for youth. The group aspect of counseling for youth might be useful for two reasons. The first is that youth really want to spend a lot of time with friends and with peers, so they might be more amenable to attending counseling and paying attention and listening because there are also young persons there that they can socialize with. What group counseling can also do is normalize the problems that young persons are going through. Because I think that young persons would be much more apprehensive or nervous about them being different from their peers. They want to fit in, but they're going to counseling because of this, what they think is a unique problem. But when they learn that other young persons, their same age, same background, are going through the same things, can kind of be helpful in letting them know that, hey, you're not alone in this. This doesn't make you like totally abnormal. There are other people that are struggling with this, and maybe that helps motivate the young person to attend and participate. Family counseling, sometimes called multi-systemic therapy, is also very useful. It involves not just treating the young person, but bringing in the entire family unit. Because just like with the ineffectiveness of boot camps or wilderness training programs, the skills or the progress that a young person makes in counseling might not be as helpful if they're then returned to a family environment that's particularly negative, where family members are drinking, using drugs, using coercion, neglect, emotional forms of violence to further harm the young person or other persons in the home. And so this family-based intervention can be especially useful to make sure that once the young person leaves the school or leaves their friend group, they're going back home to a family environment that's safe and secure and can help prevent future recidivism. I mentioned that group-based therapy can be useful, but peer-led therapy might not be useful. I think that what we know about youth is they have poor moral judgment. They can be susceptible to negative peer influence. And so the decisions made by youth in group counseling, where it's kind of peer and group led, might not be as useful as having like an actual trained clinician, somebody who's trained to administer CBT, to actually be guiding the therapy or guiding the program. So lastly, I'll talk about skill building programs as an overarching type of program. It's meant to provide instruction and practice incentives aimed at helping the young person develop like control over their behavior and their ability to participate in normative pro-social activities. So it's not just like job training, it's more like social training, especially because a lot of these young persons have often not had an opportunity to have pro-social interactions with other people because they come from a very negative family environment or they have a very negative peer group. So they don't necessarily get opportunities to practice like compromise or pro-social interactions. So these programs provide an outlet and an opportunity for this. Cognitive behavioral therapy, while a type of counseling, is not just counseling, it's also skill building because it goes through different scenarios and gets the individual receiving the counseling to practice how they would engage or interact with a particular person in a particular scenario. So it changes those neural pathways of, okay, normally if somebody cut you off in traffic or brushed by you in school, you would react very negatively and you would push them or you would get out of your car to initiate a fight. So let's acknowledge that this is what makes you particularly upset. There are specific circumstances in your environment that make you feel very disrespected. Let's not worry about like violence in general. Let's worry about those circumstances that lead to you being violent. Now let's think about alternative ways that you can handle this environment or this scenario that lead to a resolution that you'll still be satisfied with. So if somebody is walking through the hallway at school and like you think that they bumped into you on purpose, what are you going to do about it that's not going to get you into trouble? So is it going to be just walking away? Well, maybe you feel like if you just walk away, you're still going to be angry for the rest of your day and you might take your anger out on somebody else. So what can you do, whether it's like exercise or meditation, types of breathing, that can help get you out of this headspace and allow you to proceed through your day so that you're not going to get like what we call stacking, where one thing bugs you and you move on, but then another thing happens, and normally in isolation you wouldn't respond to that negative event with violence. But because these other things have happened throughout the day, you don't have that agency, that mental strength to ignore it, and so the person lashes out. So it's about not just ignoring the problem, but developing skills so that you can get back to baseline. And on that note, I'm going to talk about a particular program developed right here in Canada called Stop Now and Plan that really focuses on integrating a lot of skill building and counseling to allow persons to deal with things in their environment that frustrate them. The Stop Now and Plan program was developed in Ontario by Lena Ajameri, and it's used throughout the world. Curiously, it's only used, I think, in like 1 or 2 school districts in British Columbia. One of them is in Coquitlam, I know for sure. But like in Ontario, it's in like 60 different school systems. It's a 12-week program and takes groups of children, about 7 children, because again, we know that young persons benefit from being in a group of their peers, where they meet for about 90 minutes with a trained facilitator to work on social skills, skill building, bringing the parents into the program as well, so they can go through home practice exercises, role playing between the peers or role playing between the child and their parent. So it starts with targeting. Typically, it's targeting young boys between the ages of 6 to 11. Now, SNAP has actually been expanded as well to include a more precise version for girls, but usually because boys are more likely to be in conflict with the law, they first focused on boys who have been in contact with police prior to age 12. So the formal justice system, as we know, can't intervene, but these young persons are in conflict with the law, and we want some form intervention strategies so that by the time they're age 12, maybe they won't be in conflict with the law. There won't be a need for formal intervention. So as I mentioned, the aim is skill building, cognitive behavioral therapy, helping them develop their social skills, helping them recognize triggers and how they're going to deal with those. And so the SNAP part of it is very corny and it's only a small part of it, but it basically tells the young person, okay, you're dealing with a scenario that makes you particularly frustrated. So I want you to snap your fingers.
Hey, let's go! Snap your fingers, do you still? You can do it all by yourself.
And begin to practice those cognitive behavioral therapy techniques. Recognize that you're frustrated. And what SNAP does is it doesn't ask the person to immediately snap into action. It basically says, okay, you're frustrated. What we want you to do now is just recognize that you're frustrated. And before even trying to solve the problem, give yourself a little bit of self-confidence and say like, hey, I'm frustrated here, but don't worry, I know how to solve this problem. And then plan how you're going to solve that problem. So you recognize there's the issue, you've got the confidence that you can deal with the issue. Now plan how to deal with this issue. Take that plan and put it into action. And I'll just read off the slide here some facts about SNAP. Farrington and Cagle in 2015 did a really wide-scale evaluation of SNAP to look at not just recidivism reductions, but like social cost reductions in harm. So they did a whole cost-benefit analysis. So they found that it cost just about $4,500 Canadian for each participant. And by participating in SNAP, we saw a reduction in recidivism by about 18 to 33% depending on where the program took place. Basically it reduced like 1 to 2 convictions per boy between the ages of 12 to 20. So the boys were engaging in the program around age 6 to 11, but then they were followed up over time. So that was the real key part. Did the program actually work? And overall, the program saved anywhere between $15,000 and $27,000. So that's adjusting for the actual cost of the program itself. So taking away that $4,500 cost, by treating each individual, we saved about $20,000. So really, really quite substantial. There are also specific programs meant to target youth that are involved in gangs, and I'll be talking about gangs in more detail in another lecture. One of the more wide-scale programs, if you are interested in this, you should definitely take a class with Stephanie Wiley because she actually worked on this project. It's called the Gang Resistance Education and Training, or the GREAT program. It's a 13-week school-based program that talks about the dangers of gang involvement, and it provides things like cognitive behavioral therapy, development of social skills, refusal skills, so like how to say no to when an individual presents you with opportunities to deal drugs, and how to deal with conflict resolution. So this program's been successful. Another one is what's called ART, or Aggression Replacement Training. It's focusing more specifically on moral reasoning and anger control. We see this actually a lot in BC with what's called Violence Offender Treatment Programming. Another program is called Cure Violence, trying to interrupt violence, especially that's on the streets and in communities, by focusing almost more on like macro level, like street beefs that are not just between individuals, but between gangs or neighborhoods. I'll end today by talking a little bit about what's wrong with British Columbia. We have a gang problem in BC that's relatively unique from other jurisdictions. In south side of Chicago, in LA, in Baltimore, the individuals involved in gangs are often individuals coming from very detrimental socioeconomic backgrounds, very, very negative circumstances, or living in real serious forms of poverty, where their motivation for gang involvement might be to be able to get electricity to turn their lights back on, or their heating back on, or they need their running water in their house. So these can be what motivate young persons for joining gangs in those cities. We have this in British Columbia too. We have a poverty problem. We have youth living in poverty, but the poverty that they experience is different from the poverty experienced by someone living in Chicago. My point is that poverty in BC looks a little bit different from poverty in Chicago. it's more serious than places like Chicago. The other kind of important thing to keep in mind is we do have individuals in poverty in BC that join gangs. But we also have in BC a lot of individuals who are maybe more middle, even upper class, who join gangs. And so the reason why they join gangs might be unique from our sort of like traditional understanding of gangs. We have a problem in BC of policymakers and politicians being unwilling to fund research to figure out what works. So we have a lot of earnest, hardworking members of the community that want to help deal with gang problems. In Surrey, we have the Yo Bro, Yo Girl program, we have the RAP program. And they've received funding to implement these programs, which is great. But what we're missing is a large-scale research project to identify whether these programs actually work. We honestly have no idea in BC whether the programs that we're doing actually prevent gang involvement or prevent gang violence or prevent violence more generally, because there's a lack of willingness to actually evaluate these programs. It's because they want to fund the programs as much as possible, but we don't actually know if those programs are working. So we could be putting a lot of taxpayer dollars into programs that don't actually work. And that's not meant to blame the practitioners that are working really hard on these programs. So I talked about the different strategies that have been reviewed by LIPSI in that meta-analysis, what works, what doesn't. We don't really have an understanding of what works or what does not in British Columbia. So that's everything for today, and I will talk to you all next week.